I'm not going to be here very long. I just want to clarify some misrepresentations about my book. My book has been taken out of context. I think that it was very intentional, trying to invalidate my work, trying to bottom feed. Unfortunately, literacy is on a decline in America and probably all across the world. People don't read anymore. I think reading is important because I don't know, it sort of motivates you to have certain critical thinking skills. Where you're being spoon fed and you don't know how to interpret, you don't know how to actually read a book and actually comprehend what it's saying, then it is easy for you to be led astray. I think my book was very transparent. I know that some of the legal gobbledygook may have gone over some people's heads, but I have been going over it on YouTube and I have been giving people an opportunity to ask questions if they don't understand. So I'm going to just clarify my position. Basically, chapters 1 through 3, which basically say that this is a system of enslavement because people are not understanding what my position is. So I'm just going to clarify it, even though the book makes it very clear. Now, there's two specific misrepresentations that are being made. First, someone is claiming, you guys know who I'm talking about. Someone is claiming that I said that the Supreme Court refers to the state as the master state. And the second, that I believe that the Supreme Court validates my position that we have a right to die and that the absence of that right constitutes slavery. No, I did not say any of these things. I'm not sure what's wrong with your comprehension skills, but maybe you need to go back to the drawing board and read it all over again. Um, these positions appear nowhere in my book. The distinction between what I actually argue and what is being attributed to me is not a matter of misinterpretation. This is someone trying to basically make up shit in order to validate my entire argument because they can't actually engage with the substance of what I said. Now, let me just start out by talking about Plessy versus Ferguson, right? Because there's two different definitions of slavery and it's disjunctive. I've already said this before, and I think that I made it clear in my book that I was not using the former definition, I was using the latter. All right, so let me just read that definition. I've read it so many times, and I know you guys are getting bored, but I really need you to understand that I'm not making any stuff up. Here's what it says. Slavery implies involuntary servitude, a state of bondage, the ownership of mankind as chattel, or here's the second definition, or at least the control of the labor and services of one man for the benefit of another, and the absence of a legal right to the disposal of his own person, property, and services. Now, I don't know how, I mean, again, I've said it so many times, but I focus on the disposal rights, right? The absence of a legal right to the disposal of his own person, property, and services. I literally went through each element that we do not have disposal rights over our person, property, and services. I explain at length why we do not, because the state interferes. The state does not allow you the right to dispose of your person because it criminalizes medical assistance. It interferes with the disposal of your property because the state can destroy your property through eminent domain, or in my case, the city just, they were neglectful, right? They own a lot next to my house. They let their tree fall on my property, causing hundreds of dollars in damage. And then when I sued them, they claimed sovereign immunity. Ain't that some shit? So all this, you can say it's solipsistic all you want, but I'm living it. And I see things objectively because I've experienced it. Because I have gone in court and litigated a lot of these issues, I've already seen how this shit plays out. They claim immunity for everything. You don't have any rights. They are above the law. They can do whatever the hell they want. There's nothing you can do. You have no legal recourse. And then finally, services. We don't have the right to dispose of our services freely because you cannot earn a livelihood without an occupational license. The state has prohibited the state has criminalized earning a livelihood without an occupational license. If you attempt to earn a livelihood without a license, your ass will be fined and thrown in a damn cage. I know people who have tried to do it. They have had bank levies issued on their accounts. They have been thrown in prison through summary judgment because they don't always do it criminally. They do it civilly. Through summary judgment, they get no right to a jury trial because what they'll do is, well, I talked about this at length in my book. I've gone through it. I've talked about how it actually plays out in real time. Now, these are two independent definitions. The first definition defines chattel slavery, the outright ownership of a person as property. I did not use that definition. Not once did I say in my book that we are chattel slaves. I used the second definition, which defines slavery by the absence of disposal rights, the control of one's labor and services for the benefit of another, combined with no legal right to the disposal of one's own property, services, and person. Again, I use the second definition. I'm not sure if people are dense, and I'm not going to say plural because it's only one person who's doing it. But I think I don't know if you guys are believing this, if you're thinking that I don't know what I'm talking about, that I made this shit up. You probably shouldn't take my word for it. You probably should read it for yourself because I do say, I make this very clear, and he is intentionally misleading you guys so that you guys will think that there is no merit to my argument. He can't debunk what I actually said, so he has to create a non sequitur. I never said that the state owns you as chattel. I argue that the state's prohibition on your right to the disposal of your own existence while extracting value from your forced continuation satisfies the second disjunctive definition of slavery. Again, these definitions are disjunctive. You can go, even if you don't take my word for it, you can go back and research Plessy yourself. Look at the definition, right? I include citations at the end of it. They're presented as footnotes, but they're all there. You can verify this shit for yourself. For those of you who don't use AI and actually still read. Now, he also seems to take issue with my use of the word master. I never said that the Supreme Court has explicitly said that the state is your master. I took the Supreme Court's own legal definition of slavery, the second disjunctive definition, and I demonstrated through my own analysis that the state's conduct satisfies the second definition. The verbiage is mine. I'm calling it the master because it functions as a master based on the Supreme Court's own definition. Never said that the Supreme Court explicitly said that the state is your master. Now, I never said that the Supreme Court validates my position. This is the problem with these lawyers. They can't think outside the box. They can't come up with original arguments. They can't think critically. All they can do is cite some bullshit case law, and then they're just automatons who just regurgitate the same arguments ad nauseum. Like they're basically making these circular arguments. That's not how I litigate cases. That's not how I present arguments. I'm actually a thinking human being who does not just regurgitate shit, right? I can look at their definition and form my own analysis. This is not what attorneys do. Now, what I say in my book is that we have a natural right to die. This predates the state. It is pre-political. It does not need affirmation from any fucking court. And the state's prohibition on the right to die is illegitimate. It constitutes slavery. They are forcing you to exist. It is ultra vires. It exists outside the proper scope and role of government. So anyone who says that I said that the Supreme Court is explicitly said the state is our master, you just don't know how to fucking read. There's something wrong with you. My position is based on natural law, not positive law. I never said that there's an affirmative right to die that is recognized by the state. That is the complete opposite of what I'm saying. I'm saying that we don't need the state to recognize it because it exists independent of the state. I'm saying that the state has no right to prohibit it in the first place. The natural right to dispose of your own existence is a natural right. Now, I'm eventually going to get to David Hume because David Hume basically talks about the same thing that I'm saying. He talks about the disposal rights. I want you guys to know that this is not. I know I tried to synthesize it and put it in one book, but it's a lot of content to cover. I can't put everything in one book, and even if I did, I don't think people would read it anyway. So I'm going to go over David Hume, and because he makes the same argument that I'm making. I told you guys what property rights are according to John Locke. That property includes the person, the estate, and liberty. The Supreme Court arbitrarily made a distinction between liberty and property, and they form a different analysis depending on how it is framed. Because they don't recognize ownership of your own life as property, they analyze it under a liberty interest, which it does not get the same protection as a property interest. Again, I explain all of this. It's a lot to try to think. That's why I do cover it on here. And I open it for questions for those who don't understand. I don't know what more I can do. I mean, this is the reason why democracy is so dangerous, because you have the coercive power of the vote where you have the ability to regulate somebody's life, but you don't actually understand the power that you wield, and you don't understand how this whole process works. So your vote is illegitimate. You should not be voting on what I do with my life. Now, again, my whole premise is based on natural law, not positive law. I analyzed both John Locke and Jean-Jacques Rousseau. John Locke established that every person possesses the natural right to self-ownership, sovereignty over their own person. This is prior and independent to any government. From self-ownership flows the right to dispose of what you own. Locke's framework makes the state seizure of your disposal rights not merely unjust, but a fundamental violation of the natural order from which legitimate government is supposed to derive its authority. A government that violates self-ownership does not merely make bad policy, it destroys its own claim to legitimacy. Now, Jean-Jacques Rousseau, whose words appear in my epigraph in the book, this is what he says: the citizen is no longer the judge of the dangers to which the law desires him to expose himself. And when a prince says to him, it is expedient for the state that you should die, he ought to die. And then again, you guys are going to have to go back and read it, because this is not the only quote that I have from Rousseau. He explicitly says that the state owns your life, that you are subject to the general will, not your individual will. So whatever the collective says, there is no individual will. You have to do whatever the majority says. And then he also said that if someone violates the social contract, then the state is supposed to force him to be free, specifically saying that the state should terminate your life because you don't obey like an obedient slave. So again, to summarize this portion of it, self-ownership is a natural right, and the state strips this natural right and has converted into a system of enslavement. You do not own your life. The state owns your life. They're not going to say that. Of course, they're not going to say that. They're going to trick you to think that you're free, that you have so much autonomy that you don't actually have. Now, a lot of these idiots think that unless it's in the Constitution, it doesn't exist. We don't have rights independent of something that the state has recognized or a court has recognized. That's not what the fucking Constitution says, right? This is what the Ninth Amendment says. I know it's a lot of shit and maybe it's confusing people, but This is not rocket science, and I think anybody of ordinary intelligence can understand it. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. And what that means is that the Constitution does not create rights. The Constitution only enumerates certain rights. There are other rights that were retained by the people that predate the damn Constitution. You had common law rights. You have natural rights. So whether a state chooses to recognize your natural rights is completely irrelevant. Whether a court chooses to recognize it is completely irrelevant. Now, they have a monopoly on physical force, so if they don't recognize it, of course, they're going to exercise force to submit you to their will. That does not make it legitimate. The purpose of my book is to expose the illegitimacy of this entire slave system. The Ninth Amendment exists precisely to prevent the government from arguing that rights not explicitly listed do not exist. The right to an autonomous disposal of one's existence is among the rights retained by the people. It predates the Constitution. It is grounded in natural law, and its absence from the enumerated rights does not extinguish it. This is not an appeal to the Supreme Court for validation. It is the recognition that even within the positive legal framework that the state claims to operate under, this right exists. The state violates its own constitutional structure when it prohibits your right to autonomous disposal. This is a separate and additional indictment, not the foundation of my argument, which rests on natural law, but it demonstrates that the state cannot even meet its own purported standards. What natural law, well, the foundation of natural law that I established in my book, established the illegitimacy of the Washington versus Glucksberg decision. That was the decision where the Supreme Court says that you don't have a right to die. You don't have a right to medical assistance. And then I cited Justice Stevens' concurring opinion, which he says, the state has an interest in preserving and fostering the benefits that every human being may provide to the community. A community that thrives on the exchange of ideas, expressions of affection, shared memories, and humorous incidents, as well on the material contributions that its members create and support. The value to others of a person's life is far too precious to allow the individual to claim a constitutional entitlement to complete autonomy and making a decision to end that life. Now, that he says that I'm being a drama queen when I say that this is a glaring admission that it's a system of life slavery, that you exist for other people's benefit, not for your benefit. This is what he's saying. You exist for other people's benefit. Your life is far too precious to allow the individual to claim a constitutional entitlement to a complete autonomy and making a decision to end your life. It talks about the affection, your memories, the humorous incidents, all this bullshit that you are providing, that you are being extracted from, that you are forced to be enslaved for other people's benefits. Now, I'm not saying that the court is validating my position. Of course not. Of course he's not going to say that this is slavery. Use some fucking common sense. He doesn't have to spell it out for you. This is what critical thinking is called. This is what reading comprehension means. You want him to fucking spell it out? You want him to say that you're a fucking slave? No court is ever going to do that. I don't know. This was a Freudian slip. I don't know what this is, but for whatever reason, he's telling you why you are forced to exist, why you cannot be allowed the right to no longer exist. So, once you understand that you actually have natural rights, that you have rights that are independent of the state, that you don't need positive law to assert a right that you should already have, or you do have the right. They're just not recognizing it, which makes their authority illegitimate. You don't actually need a court to agree with you. I'm telling you that you have this fucking right, and you don't need me to tell you this. You can read the Constitution for yourself. I don't know how to let it sink in. If you don't have self-esteem enough to think that you you can actually challenge the state, right? That the state is not God. You don't have to agree with what the fucking state says. You are, according to Rousseau, you are the people are the sovereign. It's the general will. So this is why I'm not. This is why I'm not filing the lawsuit. I already know the bullshit. I already know the bullshit response I would get. They would make these very arguments that that fucking hater is making. That the Supreme Court never said that you have a right to medical assistance. Of course they're not. The Supreme Court never said that the state is a master state. Of course they're not going to admit that shit. So I'm not making my plea to the courts because the courts are fucking illegitimate. Nobody ever consented to this democratic bullshit. I'm making my plea directly to the American people. Now, the legal citations is not a plea for the system's approval. The system is never going to agree with me. The system is never going to admit what it is doing. I'm trying to expose its illegitimacy, right? So what they do, the purpose of me including this case law is not for validation. I'm trying to I'm exposing their purported justifications for maintaining your involuntary existence. They've already told you why they're doing it. Now you have this right under natural law. The Ninth Amendment enumerates your rights to natural rights. I mean, the rights that you retain under natural law. Again, it does not require validation from the court. The court is already admitting what it is doing. It's telling you your relationship to the state, that you are a subject, the state is your master. They're not going to explicitly use the word master, but the state has ultimate authority. You have no independent disposal rights. The Supreme Court itself is illegitimate because nobody consented to democracy. Therefore, their raggedy ass opinions are illegitimate. You did not consent to being born. Your parents imposed existence on you without your consent. That was the first breach. They put you in this raggedy ass matrix. You never consented to any of it. The social contract is illegitimate. The democratic criminalization of medical assistance is illegitimate. And it was decided by the majority, by the general will. A majority composed entirely of people who benefit from your extraction, from your involuntary existence. Of course, they're going to prohibit your right to exit. You did not consent to any of this shit. You didn't consent to being born. You didn't consent to being a subject under democracy. Democracy is supposed to derive its legitimacy from the consent of the governed. You didn't consent to any of this bullshit. You are governed without your consent. You are a fucking slave. The Supreme Court is a co-conspirator in your enslavement. They're not going to liberate you because the court is a part of the system. And so when they prohibited or when they recognized the prohibition on medical assistance, they were legitimizing the system. This is what they do. They're philosopher kings who use sophisticated language to justify the state's oppression. The master state is my term. As far as I know, I coined it. I don't know anybody who ever used that. They'll talk about a nanny state or something else. I wanted to use a term that was precise, that explains the functional relationship between you and the state. So as far as I know, I coined the term master state. I don't think anybody else has ever used it. It is the structural relationship between you and the state. At no point did I say that the Supreme Court uses the term master state. That is a claim being made by me, and I explained why I use that term. I explained that is the functional equivalent, that the state is acting as your master, and I explained it. I made an analogy between chattel slavery, that the master has superior disposal rights, that you exist for the master's benefit, not for your own. That you don't even actually have property rights because you don't have any property rights that are independent of the state. You guys are going to have to go back and read the book if you don't understand. I mean, I laid it all out. It's all there. I used the Supreme Court's own precedents against them, not for my validation, but to expose their own illegitimacy. I used their own definitions and their own reasoning. And then I did an anniversary card and pointed the finger right back at them. The criminalization of medical assistance is a regulatory taking of your life. You don't own your life. And there's the case law of Pennsylvania Cole versus Mahan, where this basically says that when a government regulation goes so far as to eliminate a fundamental incident of ownership, it constitutes a taking requiring just compensation. By depriving you the disposal rights of your own person, the state has used its regulatory power to take your life. They didn't, of course, you're still here, but it's a regulatory taking that you don't actually own your life. The state owns your life, and yet the state has not given you just compensation. What I say in my book is that the state has, I'll get to that in a second. I proved this positively through the disposal rights test that you don't actually own your life because the incidents of ownership include the right to disposal. Nobody's going to negate that part, though. You're going to talk about some ancillary bullshit that I didn't even say. By logic, you are property of the state. You don't own your life because you don't have disposal rights. You cannot have disposal. It's impossible under the legal framework. It is impossible to own something without having disposal rights. That's how you determine who actually owns something. Now, I had a section in there which is called the impossible choice, that because the state has taken life through its regulatory taking, the state has a choice. Either they can recognize your right to medical assistance on your own terms without any interference from the state, or they have to pay full maintenance for your involuntary existence in the form of socialism. You should not have to pay anything. You should not have to pay for your own housing. You shouldn't have to pay for your transportation, your healthcare costs, your education. None of this shit, because you are here involuntarily. And I did make I made an analysis about the slave codes, right? I even talked about Aristotle. Aristotle said that slave owners have a duty to maintain their living property. This was recognized under the Virginia slave codes, and I think I also cited Mississippi, that the slave owners had a duty to maintain their property. If their slaves, which were their living property, if the slave owners did not maintain their living property, they could actually be sued for that by their slaves. They had a duty to clothe them, to feed them, to house them. You can't maintain you can't own living property without maintaining them. Now, my book was not a reform proposal. I don't believe this corrupt ass system can be reformed. I don't believe democracy can be reformed. The whole purpose of this book is to expose the illegitimacy of this entire racket. The legal, economic, political, and moral legitimacy has been deconstructed. It's been dismantled. Every institution that sustains this arrangement and presents itself as legitimate, the imposition of life, the state as your protector, the courts as the enforcer of your rights, capitalism as legitimate property rights, have all been dismantled thoroughly and systematically. The system says you were your parents' gift to the state and to the collective. Your parents, well, they created you for their benefit, but then they turned you over to the state and basically made you the state slave. Um, they put you in this damn matrix. Now, let me just say what would need to be established in order to debunk my book, because I, I'm sure there's somebody smart enough to debunk me, but that troll, that stalker, that harasser, that I could use another adjective. You guys probably know where I'm going. Let me stop. I'm not going to be nasty today. Um, I'm just going to tell you what would need to be established in order to debunk my book or my central argument. You would need to disprove the natural law foundation, right? You would need to demonstrate either that self ownership is not a natural right, which requires dismantling Locke's entire framework, or that the right to dispose of one's existence does not follow from self ownership, even if self ownership is recognized. Merely asserting that courts do not recognize this right does not address the natural law argument. Natural rights do not depend on positive law recognition. You would need to disprove the Ninth Amendment argument. You would need to show that the right to an autonomous disposal of one's existence is not among the unenumerated rights retained by the people. And you would have to do so relying solely on the fact that courts have declined to recognize it, since the Ninth Amendment exists precisely to protect rights that courts and the legislature have failed to enumerate. You would have to disprove my application of the second definition of slavery taken from Plessy. You would need to show either that the second disjunctive definition does not apply to the state's conduct, that the state's prohibition on the right to exit and its extraction of value from your forced continuation does not constitute control of the labor and services of one man for the benefit of another, combined with the absence of a legal right to the disposal of his own person, or that the two definitions are not disjunctive and cannot be applied independently. You would need to engage with the second definition on its own terms and not conflate the two as if it is the same definition. Or pretend that I used the first definition and claim that I'm saying that we're chattel slaves, which I never said. You would need to address the regulatory taking argument. You would need to show that the criminalization of medical assistance does not eliminate a fundamental incident of ownership, or that the disposal rights test, which holds that the entity with superior disposal rights is the true owner, and that the superior ownership of disposal rights does not apply to the state's relationship with the individual. You would also need to identify where else the ownership authority resides, because if you don't have it, then who has it? You don't have the disposal rights over your own person, so who owns it? And how can you have disposal rights without owning it? So whoever has disposal rights is the true owner. You don't have disposal rights over your own person. The state does, which means that the state is the owner. You would need to address the impossible choice. You would need to identify a third option, because the impossible choice is that the state has to either grant you your right to medical assistance or maintain your involuntary existence through socialism in order to make this entire system legitimate. Now, if you think there's a third option to establish its legitimacy, you would need to establish what that third option is. Those are the only two options. Unless you can come up with a third option, then you really should shut the fuck up. You would need to disprove the ownership conclusion. I've already established that you don't own your life because you don't have disposal rights. You would need to establish who actually owns our life. Okay, and the only way you could do this, you would either have to prove me wrong to say that we do in fact own our lives, or you would need to prove that the state does not. You would either. There's only two ways to do this. You would either have to prove that we do own our lives, or that the state does not own our lives. You, there's only two ways to do this. I don't know. There's not a third option. A lack of ownership is still ownership. What it means is that you're owned by the collective. You're owned by the state. So if you don't own your life, then the state owns your life. It has to be one of the two. Or you could probably come up with some wiggle room to say that life is inalienable, that nobody owns our life. But no, I've already addressed that too. It's not inalienable. Somebody has to own this shit. Either you own your life or the state owns your life. And if the state owns your life, then you are the state's fucking slave. Regulation that eliminates the fundamental incident of ownership is, by established property law, a regulatory taken. I never said the Supreme Court validates my position. I would love for you to go through my book and tell me where I say this, because I never said that. I was invalidating the Supreme Court's position, not using the Supreme Court to validate my position. I don't need the radical Supreme Court to validate my position. I have natural law on my side. All right. So again, this is why reading comprehension is so important, because a lot of it's a lost art. People don't know how to read anymore. People don't make the effort, which is why I've been spoon feeding this shit. By the way, this is why I go on YouTube and I actually review it and try to make clarifying statements, because I already know people are not going to read it. Which is not. It's not a diss. It's not. It's not. I'm not taking a cheap shot. I just know how this shit works. You know, this isn't my first time at the rodeo. But at the same time, the person who actually did read it is taking shit out of context. Never once said that the Supreme Court said the state is your master state. I never said that. This is my own language that I coined myself. Never said the Supreme Court validates my position. What I said is that the right to dispose of your own existence is a natural right under natural law, not positive law. I said that the Supreme Court abolished this natural right and forces your continuation, and this is a violation of natural law. What I said was that the state's criminalization of medical assistance constitutes a regulatory taken, and if the state owns us as living property, it must either fully maintain us through socialism, or it must abolish these prohibitions. I use case law only to illustrate definitions of words such as slavery, only to expose their own contradictions, only to explain how the system actually functions, not because I think that the Supreme Court actually agrees with my position, or that the Supreme Court thinks that we are slaves. All right, y'all. I guarantee that Troll is not going to do any of this shit, but that's what you have to do to debunk my central arguments. This ancillary bullshit about the Supreme Court didn't say you're a slave. That's not debunking. I know you think you debunked my book, but you did not. You're gonna have to try a little bit harder. All right, y'all. Yes, it's an entire scam. It's a racket. By the Supreme Court's own definition, we're all fucking slaves. So, with that being said, I do need to go over chapter 9. And I'm technically on vacation, so I have all the time in the world to come back later if anybody's here. So I may be back later, but y'all have a good day, and be sure to listen for my